This is a very difficult testimony because it brings back memories of the anguish we went through finding that one disgruntled employee could sue on behalf of every employee we had had for the past 4.5 years. My husband and I own 8 pizza restaurants in California and employ nearly 500 mostly part-time college students. We share ownership in the company with our administrative and store management teams. Woodstocks has been in business for over 40 years, and in that time we have worked diligently to comply with all of the ever-changing federal, state, county, and city laws. We believe in our team and know we couldn't do it without them. We have poured our heart and soul into our team, and we're honored that they've chosen to work with us. One unhappy employee wrote an email to us, mostly complaining that he didn't like several of his superiors and coworkers. After he talked with a PAGA attorney, it suddenly switched to a boilerplate list of allegations like a minor error in the wording on payroll stubs. There was no dispute on how much employees were paid, simply on how we stated regular pay versus overtime pay. There was no way to substantiate whether every employee had received every paid break since they didn't clock out for those breaks. Our employees weren't paid for mandated COVID temperature checks, which took mere seconds. That was basically because we didn't document this. Another allegation, we required employees to work off the clock during mandated unpaid meal breaks. That was never substantiated. And the last one, not paying for everyone's cell phones when we gave them an option to check their schedules through an app. They could still see the posted schedule in the store. Apparently, a PAGA lawsuit usually leads to a class action lawsuit, which happened in our case, which means it includes every employee who has worked for us in the past 4.5 years. This despite the fact that not a single employee had ever complained about any of these allegations in all of those years. We were told that it would cost us more to go to court and fight this than to settle it, admitting no guilt on any of the charges. The initial amount thrown at us in arbitration was $24 million, more money than we had made in our entire history, and nowhere close to what we had available in cash reserves. It appeared that we would have to immediately shut down the company and terminate all of our employees who had counted on us for jobs. Some of our full-time employees had worked for us at least 20 or 30 years. After enduring an entire day in arbitration, we settled on $1.5 million, which we were only able to pay because we had received that much from the government in pandemic relief. So we essentially took that check and signed it over to the attorneys. Less than half of that went to the approximately 2,200 employees who worked with us over the last 4.5 years. Now, the only silver lining in all of this, we asked what happened to the uncashed checks, those that had no forwarding addresses. The attorneys said those funds could never be returned to us and usually went to some legal group. Oh, hell no. We found out we could designate what organization received that money. We chose a nonprofit called Big Table, which exists solely to provide assistance to restaurant, bar, and hotel employees. In the end, they received a check for over $213,000.